Hey there, it's Christian Walsh, real estate agent with Wire Associates, where we help landlords and renters understand their rights before things go wrong. And it is the first live stream of the year with Kenny and Zach and Raphael, but we've only got Kenny today. It's all right. Kenny can make up for all the wittiness and smarts and charms of those other guys. We don't even need them, right, Kenny?
I'll do my best.
That wasn't very convincing. All right, so it's very important to understand the guy with the tie is the attorney, so he can give legal advice. I can't give tax or legal advice. I'm just a real estate broker. But this is a very, very important live stream, and we're glad you're joining us because we are going to be talking about the unfortunate LA wildfires and the effects of that. So, what I'm going to ask you, we got Michelle in the background. She's making sure the comments stay clean. So, put your questions in the chat wherever you are. And Kenny, I know you're excited, but we actually are live streaming on TikTok right now, I think, if Michelle could get it to work. So, this could be our first and last TikTok live stream because in a few days it could be gone. So,
Depends on if they ban it completely and it goes through.
I know. All right, so All Nighter's already here. Welcome, All Nighter. So let's dive in, Kenny. First off, were you affected by the fires? My heart goes out to you, Kenny. Did you have any friends or family that were affected?
So I knew a lot of people that were affected. I knew some people that lost their homes. So I've been getting a couple of calls like that. So my family is up in the La Cañada area. So my parents had to evacuate, as did a lot of other people that I know. Some of my friends that were in La Cañada had to evacuate as well. But other than that, it seems like at least from my end, everything was fine. I just, the ash, the smoke, and just the news of hearing about everything that's going on. I've even had to deal with, I've had to, some opposing counsels that come to me and said, "Yeah, I need some time to deal with their situation," and I gave them that time because I said, it's like, your health and safety matters first and foremost. We'll handle the litigation, we'll handle the eviction, but if you're going through something that's unprecedented like this, I think that takes priority.
Yeah, and it's so sad, and I'm glad that you're okay, Kenny, and your family is. But yeah, it's unprecedented is the word for this, and it is going to take a very long time for folks to rebuild and recover from this, and our hearts go out to them and our thoughts are with them. And that's why we also wanted to do this live stream, because there are a lot of questions out there on many levels. The ones that we can focus on right now, we can work on answering, are some of the landlord and renter things that have come up. So we're going to discuss that. We're going to discuss landlord-tenant law as it relates to properties that are gone or damaged. And then we're going to dive into the price gouging, which is Penal Code 396. That's been around forever. The price gouging, anti-price gouging law, the Penal Code 396. It's been on the books, it's been enforced, it's been used for a long time, but it's now coming to the forefront in a much greater way, just because now so many people are affected. So we're going to dive in and talk about that. So first, Kenny, let's talk about what happens to a tenancy when a building is completely destroyed, as we had, where the entire rental property is literally gone. What happens in that case for the landlord and the renter?
Yeah, so I think this is the part where the law kind of coincides the most, probably with common sense, where people like just look at it and say, well, what should really happen here? The law has a very nice civil code, Civil Code 1933, that basically says if you guys have a contract for a thing and that thing terminates, basically is destroyed, then the contract is gone. So the obligation to pay the rent is gone. The obligation to rent the thing is gone because the thing is destroyed. So if the house itself is a total loss, as in basically, there's nothing left, then the contract is over and both parties get to walk away from it. That's only if the house is totally destroyed.
And that would be also the security deposit, obviously, would go back to the renter because it's gone.
Yeah, so
The
your
structure.
your end of contract obligation still exists. So if there's anything left over to satisfy on the contract, the landlord would still have to comply with 1950.5, basically doing an itemization of the security deposit. Um, there are going to be questions about whether or not you can apply some of the damage to the building to the security deposit, but you would have to actually relate that to unreasonable wear and tear and also to the tenant's conduct, which, unless you can prove they started the fire, um, I don't think you're going to get that.
Yeah, it's best just to refund whatever security deposit there is. Now, what it's going to be a spectrum essentially of destruction. On some level, you've got structures that are completely fine, nothing's changed there. Then you have structures that maybe need a little bit of work, and then you have structures that need a lot of work. Where do you draw the line in a landlord still having an obligation to make those repairs and go ahead and keep that tenancy going? Like how destroyed must a property be?
So the termination, it's going to be unfortunately on a case by case basis, and I'm going to give the answer that every attorney gives. It depends, and it depends on if the building itself is still habitable by the tenant, and if that is the case, the obligations for everyone is still there. So the landlord still has an obligation to keep the property in a habitable condition, so they can't breach the implied warranty of habitability, even if it's a disaster like this, with these wildfires. So essentially, if there was roof damage or some kind of wall damage or something because of the fire, the landlord is going to have to make those repairs and deal with it. So again, it really goes down to whether or not, if you are going to be able to legally have somebody inhabit the unit itself, then, and if both parties are still agreeable to continue the contract, then yeah, the obligations would stand for both sides. The only time where legally it wouldn't is if the city comes down and says, or red tags the building or decides that the unit itself is inhabitable. The city can make a legal determination off of that, and at that point, the landlord would have to take steps to comply with the notice or comply with the city notice that was given to them. Unfortunately, a lot of these are going to be on a case by case basis.
Yeah, and it's interesting too. I mean, part of what they've done is they've removed some of the restrictions. For example, in having a trailer set on your lot so that you can live there while the structure is being rebuilt. So it'd be interesting to see if any renters will attempt to stay in a trailer until their structure is rebuilt. I guess the contract's over, so they wouldn't have a right to do that. So, any thoughts
Yeah,
on that?
you're going to get a lot of, for better or worse, you're going to get a lot of cases where people are trying to help out, and unknowingly violate some arcane law that they never intended to violate at all. So, and this happened during the pandemic as well, where individuals said, "Hey, look, I know you're affected by something that's outside your control. The pandemic was one of it. The wildfires may be this time around, and I'm going to let you live in the unit rent free." And then, it's like 3 weeks, 4 weeks, maybe a month, 2 months down the road, it kind of gets a little bit burdensome, and they realize, well, this person might have tenant rights now. So essentially, if you're going to be doing this, ultimately, I think that individuals need to protect themselves first and foremost, but also at the same time, try to help out the best they can. But I do think that they need to protect themselves legally the best that they can by reaching out to an attorney, reaching out to someone that can tell them what their potential liability would be if they take these actions.
Yeah, and the other thing too is following up with a good attorney like Kenny and the California Property Law Group, because the landlord-tenant laws are changing. For example, LA City Council met and they've reintroduced some of the emergency protections that we had under COVID, but not all of them. So, for example, if you bring in an extra occupant and a pet, uh, because you're helping out somebody who's been affected by the fires, you can't have an eviction due to that. But they did not do a rent freeze, nor did they do an eviction moratorium like we had during COVID. They talked about it, and they're reaching out to do more research on it and see. Anyway, this is we're starting to get some great questions here, so I want to touch on these. This dovetails into what you were saying in the beginning, Kenny, where you were giving the opposing counsel more time because they're dealing with difficulties. Have any cases been dismissed yet? I know it's still very early into
So
this, but
yeah, so not dismissed, but delayed, for clear reasons of the fire. Prohibiting people from being prepared, being ready, things like that. Um, I guess if you want to say some cases where the building itself was destroyed, you do need to dismiss the case because there's nothing to fight over at that point,
yeah,
and that was an unfortunate reality for some of our cases. Um, but if you're talking about a legal dismissal, if you're talking about how the law would protect or stop certain evictions, as of right now, no. But as Christian had mentioned, LA City, they really did try to consider doing an eviction moratorium, very similar to the one they had during COVID. And they did basically, they are going to adopt a very similar ban on additional occupants and pets in LA City. But again, the one thing that I do want to point out, and I've always pointed out in many of our other shows and lives, I've always pointed out this is LA City. And if you are not in LA City, this does not pertain to you, your house
yeah.
particularly. So again, it's very important that you know exactly where you are because other cities may not be following the same precautions and rules that LA City is.
That's true. So the Palisades fire falls under LA City for the most part. The Eaton fire does not. That falls under LA County, if I'm not mistaken, Kenny.
Yeah, the Eden Fire is going to be closer to places like Alhambra, Pasadena, the San Gabriel Valley,
Yeah,
that area. And there's many, many incorporated cities in that area that are not LA City, where they're doing their own variations and rules. The biggest community would probably be Altadena, Pasadena. Uh, Unfortunately, Altadena took the brunt of the fire from the
yeah.
Eden Fire.
So upsetting. So let's start diving into these questions. Lisa, the wall heater's broken. Contractor's waiting. It's been 2 days. How long to repair? And should you provide a space heater? I would this time of year. This is a time of year where it's chillier at night. If you had this same issue or in the middle of the summer, the space heater may not be as important. Kenny, any thoughts on this?
Yeah, so the biggest thing when it comes to any kind of lawsuit that would deal with implied warrant or breaches of implied warranty of habitability is you cannot be essentially the last, or the other side cannot be the last person to communicate what's going on. So if you say, "Hey, I'm going to send a contractor over there," and then silence and nothing happens, that's a problem. If they say, "Hey, no one showed up, can you send someone?" and there's silence on your end, that's a problem. But if you say, hey, someone's going to be there in 5 days or 10 days, that might be longer than the other person wants or the other side wants. But if they don't tell you anything, that's fine because you're communicating, you're actually engaging in the process and saying, I'm trying to fix this issue for you. And that's what reasonableness is. A lot of this goes towards the reasonableness behind someone's conduct. And if you can show that you are openly communicating what your intention is and what your conduct is going to follow through with, you're going to do probably the best in safeguarding your rights and basically ensuring that you're not going to get hit with some kind of lawsuit.
That's smart. That's good advice. And then to just like during COVID, if you're in LA, during COVID, you remember how long it took to get parts and how long it took to get people and things done. We're going to find that in LA with the fires where if you need a contractor, it's going to be hard to find them and it might be hard to find parts. So that's great advice, Kenny. Just keep communicating. And that's going to help do wonders. And to be honest, I think most people are reasonable if you communicate with them and let them know. So, all nighter, this is a great question. Touch on tactics unscrupulous vultures may use to scam victims, what to watch for. We're just going to briefly touch on this, but I think that would be good for a live stream all its own. And we'd need like a few different types of attorneys and as well, because some of my videos I've done, like LA County, everything in LA County, the assessor's office has an e-notification program where it basically puts a watchful eye on your property. So anytime a deed of trust is filed or a grant deed or quick claim deed, any changes to the title like that or a foreclosure notice, you'll be notified via an email within 48 hours. That's where I see some of the biggest issues because we've had so many documents destroyed identification documents as well, people will have an easier time potentially of pretending they're someone else. And I could see a case where properties are going to be sold or encumbered without folks knowing. And that's just one of them. There's going to be fake contractors out there. There's going to be fake contractors out there collecting deposits. Kenny, anything you can think of off the top of your head for unscrupulous?
When you were talking about recording with the county recorder's office, I just wanted to tell a quick story about that.
Yeah,
Um,
please.
I was back when I was in undergrad. I was volunteering at a law firm, and they had me go to the county recorder's office just to check it out and file some documents. And being that young, I wasn't quite sure what the process was like, but I was very very shocked to realize how easy it is to file documents with the county recorder's
Mm-hmm.
office. They don't care who you are. They don't care what you want. They don't even care what the document is. They look at the top. They look to see if in form it satisfies their requirements, and they'll record it. So you can record any kind of documents on any kind of properties without having any kind of ties to that property, and LA County will not do much to safeguard your property rights at that point. So yeah, if there's any kind of service, I think like the one that Christian had mentioned with the LA County Tax Assessor's Office giving you an alert, that's very smart because that'll at least tip your hand in saying, hey, someone's recording something on my property that they shouldn't be. It's a very good one. When it comes to other unscrupulous acts, yeah, just if you're trying to rent something out and someone's asking you to pay some kind of deposit or some kind of rental application, and they've never met you and they don't want to meet you, or they don't want to go face to face, there's red flags. These are things that when you see red flag after red flag after red flag, don't ignore them. Some things are too good to be true. So follow up with your gut instinct on some of these things. So
And they'll
um,
be convincing. Like they'll talk to you on the phone, and they'll weave a convincing web. Because I've had that happen with my for sale listings or my lease listings, where they're on Craigslist or Facebook Marketplace. So stay off of those, please, both of those. But they'll be on there, and they'll have a convincing tale. And it's one of my listings. They've stolen my pictures. They're collecting money from people, and this the LA fires will give new awful stories to weave. So that's good advice, Kenny. I appreciate that. But yeah, we need to do a whole show devoted to that. All right, so let's start to talk about Penal Code 396. That is a big one, and it is the anti-price gouging. So there's a good question here that we have from Grease Lightning, or Lighting, I should say, not Grease Lightning. He's going to be listing listing a furnished home for rent. If I receive multiple offers, am I allowed to take a higher offer? That's a good question I have. So the motivation behind this question is, just to give background on Penal Code 396, it caps prices on various things, bottled water, contractors, like food, all kinds of different things. Can increase prices to take advantage of people. Same thing with housing. There's limits on how much rent can be increased, and rent can't be increased more than 10%. And that's 10% for a tenant who's in place now, which there's other protections. It's rare you can do that, but particularly in LA. But it also limits that on new tenants. So if you have a vacancy and you're moving a new tenant in, you're capped at 10% of what the last amount of rent was charged. Or, and Grease Lightning brings this up as well, that it hasn't been rented out before, there's caps on that. And I'm going to talk about that briefly. So the other thing I wanted that is very important about Penal Code 396 is it's whenever there's an emergency declared, it could be presidential level, it could be statewide level, it could be county level. So obviously it's an emergency that's been declared in LA. The protections under the anti-price gouging are in effect for about a year. But what's very important to understand is it does affect surrounding counties, and doesn't necessarily mean that there's an emergency order in effect in Orange County, for example, but we still have to abide by this. So that's very important for people to understand. And I'm going to do a video on this, and I'm going to let Kenny talk. I'm getting excited. Sorry, Kenny. I'm taking over. So I've
You're doing
found at
great. You're
least
doing great.
three spots, at least three, to report price gouging. The California DRE, the Attorney General for the state, and then LA City set one up, and I'm sure there's more out there. So there are going to be a lot of people out there looking. So you got to be careful if you're going to be renting anything at all, any housing at all right now. All right, Kenny, jump in. Sorry. I get excited.
Yeah, no, so I mean, you pretty much hit everything on the head there. A lot of this, the funny thing is that people are talking about it a lot more recently when
Yeah.
it's like this law has been in place for quite a while now. And actually, it was in place back during the COVID pandemic as well. But a lot of people, the reason why it didn't really hit as hard back then, or yeah, back then is because there is an exemption where it says if there is something or if there is a more local law that restricts you even more, you need to go forward and obey that law. So locally, there were laws that said you can't raise the rent at all. So price gouging couldn't really happen because you just couldn't raise the rent. Right now, there's no restriction on raising the rent except for the anti-gouging statute. So people are talking about it a lot more. But long story short on this is that, yeah, if you were listing your house, let's say you're listing your 3-bedroom house for 2,800 or $3,000 a month, um, you can't all of a sudden jump to $7,000, $8,000 once you realize once you realize that the fires happen and people are gonna be willing to raise it for that or rent it for that. So it's not going to be this. Well, let me rent it for what the market will bear. You have
Yeah.
to keep it within the 10% limit. The only exemptions that would apply would be if you can attribute the reason as to why you're going beyond that limit to an increased cost related to the actual property itself. So if your insurance premiums went up, if property tax went up, or if something went up that relates to your managing of the property, your expenses related to the property, then you can raise it beyond the 10%. But obviously, the more you kind of go into that, and the more you try to justify that, the more murky and more dangerous you get in terms of maybe catching a stray lawsuit.
Yeah. And there's going to be a lot of people out there that are looking for it. I know part of the justification for the eviction moratorium that was being run up the flagpole by the LA City Council, there were a bunch of folks who showed up bringing examples of price gouging, and you're seeing it on the news. What I put up here, if you squint, maybe you can read it. I'll send you everybody a link in one of my future videos. But this is AB 1919, the most recent update to Penal Code 396. It's worth reading. And yes, Kenny knows I spend a bunch of time reading stuff like this. But so to answer the question about if it's never been rented before grease lighting, sorry, it's actually stipulated in here. And what it stipulates is that your initial rent, that rent you can charge if it hasn't been rented before or it was longer than a year ago, the most that you can charge for the rent, all right, get ready to write this down. It's 160% of the fair market value for that property. And then you can tack on another 5% if it's furnished. So what you need to do, and I'm going to have a video where I show this, you need to find HUD's guidelines for the number of bedrooms for the property. You'll get your number there. So let's say it's 4,000. Then you're going to multiply by 160%. So what is that, like 6,400? I'm just doing that off the top of my head. So anyway, and then if it's furnished, it's another 5%. So that would be the maximum rent you could charge. Now, in many cases, this will be fine for housing. Where it runs into issues are luxury homes. They're not going to pencil. But at any rate, that's what you would use. Calculate that number, grease lighting, and use that number to be safe. That would be that would be the rate you could charge. The problem that people have been asking me, well, homes in my neighborhood before this were going for 10,000. Why can I only charge 8,000? And that's because it wasn't a rental before, and you have to fall in these rules that were set up. So you get pinched that way. and it's basically what it's trying to do is, and you're seeing it out there already, where people are like, oh man, I could just put some furniture in this place and charge 15,000 a month, and the insurance company will pay for it, so I'm not taking advantage of anybody.
I
Well,
read
guess
that
what it
one. Yeah.
says right in Penal Code 396? It doesn't matter who's paying for it. Even if it's an insurance company, you still can't do it.
Yeah, the insurance
So,
company one I've heard, and I always got a laugh out of that one. It's
yeah.
like, well, if I get paid, then who cares if I get sued? It's like that's a great take. Yeah.
Yeah, price gouging is price gouging. Yeah, so then all nighter, HUD housing and urban development find fair market. Yeah, so you'll be able to find it for your local area. Again, I'll do a video on that. Um, so to answer the question, if you get multiple offers, what it sounds like, if you get multiple offers, you just need to be careful and still go with one that's no higher than 10%. Is that
Yes.
correct, Kenny?
Yeah, so you still have to fall within the guidelines of whether or not you can actually go beyond the 10% or not. Obviously,
Mhm.
if you have extra increased costs, then you can justify that. And a lot of it is going to be based on, you know, can you actually relate extra costs to your property? And to a certain degree, I would actually gather that based on the fact that a lot of these insurance companies, they are going to be leaving places like California. Um, you hear these stories of these insurance companies that are announcing, it's like it doesn't make uh, they can't be solvent in certain states because
Yeah,
of just the risks that they have to pay out in certain situations like this. Um, Certain estimates that I've seen from just the damage alone are in the billions of dollars.
yeah,
And if you're an insurance company that says, "Well, am I going to take that risk? For thousands, if not hundreds of thousands of homes?" A lot of these insurance companies aren't going to do that. And then what do? They're going to pass that cost on to the consumers.
yeah.
So if you can relate those increased costs, then I wouldn't have a problem going beyond the 10%. Just make sure that you're willing to justify it or that you're able to back it up as to why you did something like that.
For renters, if they find somebody who's well above the 10%, but they're in an emergency and they need to lock a place in, would you advise that they just go ahead and lock it in, sign that lease, and then go ahead and fight it after the fact? Is that the best approach if you're in an emergency?
So if you're talking about the emergency from the tenant's perspective,
Yeah.
yeah, I mean, ultimately, lawsuits are going to take years and years to resolve itself. That doesn't mean that you can just break the law and get away with it. But ultimately, if a decision between your health and safety is going to be determinative of whether or not you think that the fair market value should be lower, I think that I'm always going to choose your health and safety first and foremost. So if you want to lock it in and then say that was, price gouging, you can file your lawsuit down the road when you're in a better position to do so. Or at the end of the day, if you can try to find a different unit. There are many units out there that are renting, but I would always say that if you're thinking about somebody is if you do think that someone that is renting a unit out is price gouging, but you have no other option, I would take it first and then file your lawsuit later.
Okay. And then how about a landlord who maybe didn't know and made a mistake and exceeded the 10%? They have a lease with somebody. Would you recommend that they redo it, re-sign the lease at the legal amount, and maybe even refund some money just to be safe?
Yeah, I'm always a proponent of full transparency and clear communication. That whenever you realize that you violated the law or something is not going right, I always recommend that you try to make amends without having to incur legal fees or attorneys that will make things inevitably cost more. So, I've, just I guess as relating this to unlawful standards to a certain degree, I've had many clients who kind of go through evictions regularly. They come to me and say, it's cheaper if I just talk to my tenants and resolve it without attorneys. And I said, well, you've caught on. You've caught on. Um,
Surprise.
because it's like it's cheaper, it's faster, and it's better. And it's like, well, the world would be a lot better if you could just talk to people and resolve your problems without having to hire attorneys and say, well, I don't. This guy's my guy that's going to fight for me. And it's like, well, so yeah, I've had a lot of clients who come to me and said, yeah, like I realized my life is a lot better if I go and actually am proactive about these problems and try to resolve it and make things right up front. So Yeah,
I
I think
love
that
it.
you'll get less of a headache. It'll be better for you in the long run. If you realize that you're in violation of the law, um, continuing to be in violation of the law is not a good policy. So my recommendation would be to revert it back, and try to be within the confines of what the law says. But again, like I mentioned before too, if you can link what you did to an acceptable exemption, like increased costs, then you could stand on that.
All right, so we'll have more of those questions, I'm sure. Carmen, good to see you. If you rent a room in your single family house to a person and they don't pay rent, can you give them a 30-day notice to vacate in Calabasas? You can give them a 3-day notice to pay or quit, right?
Exactly. So you're still running into the same 3-day notice for rent. Nothing has really changed so far
Yeah.
in terms of your ability to evict for non-payment of rent. I don't imagine it will change. I think that there's going to be quite an uproar if any city council decides to try what they did back in COVID. Um, I'm not, I'm never going to say never, but I would be surprised if that one got through. But yeah, you could just serve a 3-day pay or quit for non-payment of rent still.
All Nighter has good advice. Choose the best tenant rather than the highest number. He means applicant. But yeah, I agree with that. Going back to choosing the best applicant. And the law has actually changed related to screening tenants. Make sure you watch my video on that. Essentially, you have to refund application fees for those you don't choose. So there's two paths to take there. So Wayne just found out about AB 1482. He wasn't aware of the law. Still a lot of people learning about it, both on the landlord and tenant side. They've been there for over 10 years, month to month. He wants to go ahead and give the exclusion from AB 1482. Based on what we've talked about in the past, Kenny, he could just give that notice of exemption. He doesn't have to do the change in terms of tenancy because the lease is so old. The tenancy is so old.
Yeah.
But what do you say?
So for leases or tenancies that started before July 1st, 2021, you can always just give that one exemption notice saying, hey, this new law that passed in 2019, I'm exempt. And that's sufficient. There's no timeline for you to have to comply with that by. Obviously, the earlier you do it, the better, so everyone's on the same page. But you can give that notice at any point in time. That notice changes for tenancies that started after July 1st, 2021. So that language has to be in your lease agreement. And if it's not in your lease agreement, you're going to have to amend your lease agreement to contain that language.
So let's talk about that for a second. So if I know if they're month to month, they've signed a lease after, let's say they signed a lease in 2024 and they're still, and now they're month to month, you'd give a 30-day change in terms of tenancy with the exemption notice. You'd have to wait 30 days and the property's exempt. What if they're on a lease? Like, what if they're 6 months into a lease? You just got to wait till the end of the lease, right? Or what do you
Yeah.
do?
So, I
Hmm.
mean, a lot of people kind of think, well, I'm stuck here. I'm stuck on this lease for like a year. And it's like, it goes both ways.
Hmm.
The landlord also has to honor the fact that they signed a year-long lease, and the tenant also has to honor the fact that they signed a year-long lease. Now, sometimes people say, okay, well, if you let me get away, I'll go away, kind of thing. And it's like, if no one wants to enforce it, then great, no one's going to enforce it. Um, but if you're on like a 6-month lease and you're saying, I want to amend the contract now, you can't unilaterally do that. You've already agreed to 6 months.
Yeah, with all its good and its bad.
Yeah.
As long as it's not against the law. You can't have a tenant waive their statutory rights, by the way.
Yeah.
uh,
I've seen people say, well, they waived the right to a jury trial. It's like, hear that one all the time.
yeah, no, that's good. Samuel, under what circumstances is a tenant required to pay money into an escrow account? Is this common practice in California the way it is in other states? I know a deposit. We don't really use an escrow account, but maybe Kenny will add some light to this. We ask for a deposit in California, and the landlord holds on to that, and theoretically gives that back when you're done with your tenancy, minus any fees for above and beyond normal wear and tear. So it doesn't
Yeah.
have to go into an escrow account, does it?
Is this referring to a security deposit, or is
I don't
this?
know.
Yeah, because
Samuel, go ahead and add some more questions to that. I was assuming it was the deposit, security deposit, but all right. So let's talk. So that's it for questions. You guys had a lot to ask, but not much more. So we'll switch off of fire specific stuff for now, and tell me how it's going with AB 2347, where the unlawful detainer, the renter now has 10 court days to answer. Kenny, have you guys started seeing that yet?
yeah, so funny story. Sometimes the court gets a little bit too excited, and sometimes they'll start changing their forms early December.
Oh,
So there have been some cases because we're still in January, and those cases are now maturing. And there are some people who are like, I had 10 days to file because the court back in December when the law wasn't in effect were issuing summons that said, hey, you got 10 days to file a response.
oh,
And when people get these summons, they're like, I'm gonna listen to what the paper tells me. The paper tells me I got 10 days. And
yeah.
it's like, no, actually you don't. But then it's like, okay, well now you have to fight it out with the court. You have to explain to the court that it's like, well, you told me I had 10 days. I responded 10 days. So yeah, it's still a mess. The courts are still trying to figure things out. The gears of the government kind of go very slowly. But the 10 days, it shouldn't delay the case too much. Time for um, Most of the time, honestly speaking, for the delay in unlawful standard cases are two pieces or two bits. Number one is still the jury trials. The jury trials are still a sticking point for a lot of the delays. And secondly, it's the sheriff lockouts. The
Mhm.
sheriff lockouts are a very kind of sticking point for a lot of these cases, whether it's because of lack of funding or lack of training or lack of personnel. They're taking anywhere from 2 to 4 months to do a lockout. That could be as long as the case itself. It could double the time. And some sheriff's departments they work faster than others. Some of them are smaller, some of them are bigger, multiple different jurisdictions. And not to relate it back to the fires a little bit, but this past week, many of our lockouts have been canceled. Understandably, because many of the law enforcement personnel were being diverted away to fight the fires.
Yeah.
So that only aggravated an already deteriorating situation with the sheriffs.
Yeah, and the surest way to go ahead and extend that process of a sheriff lockout, if you want to extend that as a landlord, is to call up every day and ask when the sheriff's coming out. You told us that, Kenny. They'll promptly take your file and move it right to the bottom when you do that, right?
Yeah, people forget that at the end of the day, when you're talking to someone, that's a person on the other line, and they have some kind of, I guess, authority to work on certain papers that come forward. And I've had some cases where some of my clients would call every day, and essentially the response from the sheriff department was, if they keep calling, we're gonna put this at the bottom of this of the stack here.
Yeah.
Just telling you that. So yeah, it's not as if your attorney isn't working on the case. The sheriff just takes a long time. And whether or not we think that more funding will fix the issue or not, that could be a solution. But that's the reality. The reality is that the sheriff will take probably somewhere between 2 to 4 months.
All right. So All Nighter brought up a good point about escrow can be used during a dispute to verify a tenant is still paying, say, a warranty of habitability. LA has an entire program around this where essentially they take the rent money until a landlord makes the repairs. So they guess that would be a good example of an escrow.
Yeah, that
Um,
would be the for rent controlled properties. That would be REAP, or actually, you could just apply if you believe that a landlord isn't complying with their obligations as a landlord. You as
yeah.
a tenant can apply to be what's called the REAP program,
Yep.
the rent escrow program. But the REAP program, the name sounds very scary, and to some landlords it is scary because they can never get out of it.
Yeah.
But tenants are then allowed to pay into an escrow company their monthly rent, a reduced amount, until the landlord actually fixes what they need to.
Yeah, I've had a couple clients where they inherited a property and ended up in the REAP program or inherited it and were in the REAP program and can't really do much, can't sell it. It's not easy to sell. So you gotta take care of those issues. Carmen has a question about serving. Um, so if you want to do an eviction, tenant's never home, hard to reach, and you don't know where he works because he's a contractor, how will he ever get served? So Carmen, number one, and I know you know better, but you're going to hire a pro like Kenny and the team for the eviction. And Kenny and the team are going to use a process server who's pretty darn good at serving. But in the event that they can't, then you can go to the court and ask to serve by mail, correct, Kenny?
Yeah, so there's when it comes to evictions, there's two moments or documents that generally have to be served onto the tenant. The first is the notice. The notice can always be posted and mailed if no one is at the property. So you don't need court's permission to do that.
So that would be the
Obviously,
notice to terminate tenancy, the 3
yes.
day, 30, 60, 90.
Yeah, it would be the notice that starts any eviction to terminate the tenancy. That's going
Okay.
to be the first step, and you don't need a court permission to do that. Secondly, when you file the eviction lawsuit after the notice expires, that one you have to make good faith efforts to personally give it to the defendant. After multiple attempts, you're allowed to ask the court for permission to post it and mail it if you can show that they're never going to be home, they're never going to let you in, and they're not going to take service of the summons.
Yeah, I've been there before with you guys where somebody's very good at evading it and you just get that permission. Samuel, more about the last person to communicate concept when it comes to habitability complaints. He has a tenant who refuses to acknowledge that the mold remediation was effective, and they continue to ask about mold remediation. What would you advise in a case like this, where the renter seems to think, despite Samuel's best effort, that the issue's not gone?
Yeah, so this is just a general principle that I like to hold on to, which is, and it's served me well in terms of avoiding, you know, some kind. I treat it more as a CYA kind of thing, where anytime that you have legal communication with someone that you have contractual obligations with, if you are the last person to make a statement to say this is what's going to happen, this is what I'm going to do, this is what I need from you, the ball is more or less in their court to act. If they are then going to ask you specific questions that are not related to your previous request, you could just refer them back to your previous email. Just, always be the last one to respond. That way, there's no questioning that you are actually trying to resolve the issue. If somebody is going to be giving you requests that are unreasonable or just flat out wrong, you can always refer them to any other previous communications, or you could refer them to getting legal assistance, or if they want to reach out to an attorney, you can have them do that. But the previous concept that I was talking about really dealt with trying to put yourself in a position where you will look good in front of a judge, a jury, because you were the one that said, I'm doing this, that's what happened, and the other person didn't say anything back to me.
That's great. And so then, to use Samuel's scenario, for example, this mold remediation, I'm assuming when the work was done, there was some sort of final report. Then you can go ahead and, if the renter keeps saying, hey, I still have mold, you could refer them back to that final report showing it was all clear. That would probably be an example of what you're talking about.
Yeah, and just refer them back to the report and say, this is what the report says. If you have any issues with that, let me know.
Got
And
it.
if he says, I don't agree, you can ask him like, hey, like, what do you not agree with on the report?
All right. So going back to what we were talking about with notices, the first notice is the most important notice. Call Kenny so they can guide you. Amen, Carmen. Well said. They'll guide you in the first notice, the 3 day, 30, 60, 90, whatever. So then Carmen clarifies that they've already been served the 3 day pay or quit. Now it's starting the eviction process, and the processor has been having a difficult time serving the tenant. So this would be an example where you'd get permission from the judge to serve it by mail. Grease Lightning has another super important point wrapped into this question, and I keep forgetting to mention it when I talk about Penal Code 396. Are these wildfire renter protections only for those from areas affected by the fires? And the short answer is no. These are protections in place. They blanket over the entire area, and it's for everybody. And the reason you could see why it would be for everybody is that you could see where suddenly you have 1,000 extra people moving in who are relocating from wildfires. Prices of everything would go up. That would affect the locals who aren't affected by the wildfires directly. So that's an important point, that the wildfire protections aren't only for those that are affected by the wildfire, and you don't need to have any proof under Penal Code 396 that you are affected by the wildfires. You just have to be in the area that falls under the code, right, Kenny?
Yeah, and like if you ever just took a map of any county, any city, um, even if you take a look at some of the states, they don't look like regular shapes. And so if somebody was to say, "Oh, well, a 2 by 2 square mile here is the only place where it matters," that's not how human beings kind of interact with each other. If I'm in a fire, let's say in Pasadena, and I need to relocate, I'm not going to neatly go down 1 square mile and say, this is where I'm going to be because this is the fictional line of the jurisdictional limit that I can move to. If they have a place in K-Town, if they have a place in Long Beach, that's where they're going to go to. So a lot of these protections are meant to encompass people that are going to affect other neighboring areas. And that's the logic behind why it's a blanket protection like that.
Yeah, and again, it's important to understand that, for example, in LA right now, they're under there's an emergency order in place. It's good for almost an entire year, just over a year, and that is in effect in LA. Orange County, San Bernardino, Riverside, those adjacent counties are also essentially under that same thing. And they'll go after Bonta, the Attorney General, has already said that it isn't just in that one county, it's the surrounding counties as well. And they'll go after those people in surrounding counties as well. So while you can look up, there's a chart you can get, and I'll show it in a video when I do a video, where you can see, okay, what emergency orders do we have in place right now? Don't just assume that because there isn't one in Orange County that you're exempt from Penal Code 396. And it's interesting because, again, it's folks who are bringing new rentals to the market. It's people in existing rentals, and it's people moving out. So you lose some of your vacancy control, or is it vacancy decontrol or vacancy control? I always get those backwards, but
Vacancy decontrol, because you're trying
yeah,
to get out of it, out of the control of the government telling you how much you can raise the rent by or how much you can charge for it.
exactly. So you're capped at that 10%. Okay, so the new security deposit law that goes into effect, we're switching gears here, just talk about new laws. So you're going to be, as a landlord, you're going to be required to to preserve photographic evidence. So in April 1st, 2025, you have to start giving, when you're returning a security deposit as a landlord within your 21 days, you're going to have to give before pictures. So before you did whatever you did, which is maybe you repaired something and fixed this and that. And then you're going to have to give after pictures. So that's April. Then in July, you're going to have to do move-in pictures plus those before and after pictures. So Kenny, you always talk about treating being a landlord like a business. This is just another layer of that, where you got to be organized or you're not going to be able to deduct a penny, I'm assuming.
Yeah, and a lot of times people will say, "Oh, well, if I can just attribute it to something that, like, let's say that I think this is beyond the usual wear and tear, and they don't have evidence behind it." Um, when you go to court, if someone sues you over it, they're not going to just take your word for it. They're going to say, "Show me the pictures, show me the evidence." There have been many trials that I've done, and when I've spoken with jurors at the end of almost every trial that I've done, um, they all kind of say the same thing, where it's say, why did you find this way, or why did you come up with the result in this direction? And they said, well, the evidence was there. Or if they said, why didn't you find in favor of this, they say, well, the evidence wasn't there. So if you aren't going to preserve the evidence and saying, I'm deducting because the wall looked like this when they moved in, now it looked like this, then you're going to have a very hard time showing or proving or persuading someone to side with you on that. And a lot of this is something that a lot of landlords kind of need to get into better shape with. to preserve and make sure that they don't get caught with their pants down.
There's literally zero downside for a landlord other than the extra work. Zero downside to having spectacular photographic evidence of what your unit looked like before they moved in. Like this will put so much stuff to rest of they said, I said, that it's going to be once landlords start doing it and getting a system. Like for example, I'm going to recommend that landlords use a 360 camera because the idea you just stand in one corner and maybe shoot one picture, that's not going to do it. Use a 360 camera, capture a whole room. So anyway, that'll be more content to come on that. 2025, I mean, obviously these wildfires have thrown a huge wrench in everything here for you, but what are you expecting in 2025, Kenny, in our last few minutes here from a landlord-tenant side?
I mean, outside of the additional occupant and the pet ban in LA City, I'm still expecting the right to counsel to pass at some point. Um, Also, surprisingly, I do think that the courts are catching up on the jury trials assignments. They are getting more assignments put out, so that's a plus as well. Um, and it also, I think it's somewhat in response to the wildfire situation. I do think that you are going to see a shift towards kind of more aggressively building more housing because I think a lot more people are starting to realize the price of housing is astronomical in California. And to a certain degree, I do think that it kind of reflects back on our ability to actually build housing. So this is just um, my own take and my own opinion, but I do think that we are going to be start seeing hopefully more construction of housing in California.
Well, what I would love to see now, rebuilding Altadena and Pacific Palisades, Malibu, it's going to take a long time. But how great would it be if we could easily incorporate an ADU into each one of these homes going up? We could double the amount of housing.
Well,
Um,
the issue, so the ADU thing kind of gets me sometimes
all
because
right,
a lot
lay
of
into me. I want to
no,
see
no,
you angry, Kenny.
no. No, I do think that ADUs are a very good um, social benefit, and they will help the housing situation. It's just that you trigger so many other laws that you have no idea that you were triggering as well. So one of the ones that I always point out
Yeah,
to is for rent control.
yeah,
Sometimes you have a single family home, and you're like, oh well, the law lets me build an ADU in the backyard. I can convert this garage into an ADU, and I'll rent out the back unit. Little do you know, all of a sudden now your front house is rent controlled.
yeah.
And it's not as if you meant to break the law. It's not as if you were trying to be an unscrupulous landlord who decided that I'm going to try to make more money off of people's backs. That's not what you were doing at all. You just thought I was going to make an ADU. And unfortunately, now you've caught yourself in a position where you have someone in the front that's giving you problems. That person realizes that what you've done is illegal, even if your intention wasn't to do that, and now you're going to be out tens of thousands, if not hundreds of thousands of dollars because you made a simple mistake in trying to improve your situation. And I think that's kind of the situation that I really don't like with these ADUs because I've
I
seen many landlords go through that problem.
I agree with you 100%. That is the hidden danger in this. And quite honestly, a shame on LA City Council for not addressing this. And this, if they really truly wanted more housing, they could address this issue and leave houses that add ADUs out of RSO. But they've decided, nah, we'll just kick the can. So I do agree with you. That actually makes my blood boil. And so we're on the same side, so we don't have to yell at each other. We'll
Yeah,
yell
well,
together about this.
LHD has also made it very clear to me when I've talked to them about this. They say, they want their fee. They want their registration fee. So they're gonna aggressively go after these. And the crazy thing is, you have to pull permits for the ADUs. So they're just scouring their records, being like, who pulled ADU permits? Let's go see if their unit was built before 1978 now. And it's like, okay, we're gonna register all these units now.
Unbelievable. Well, they could get them under the JCO ordinance if they just want to move them into the JCO. Now all landlords under the JCO have to pay their 31 some odd dollars for the privilege. Ms. McLean, good to hear from you. I remember you. And so she has a condo that falls under the RSO, not for rent control side of things, but for the just cause side of things. So this is a good question. So it doesn't sound like, and we talked about this a little bit in the beginning about whether a unit was destroyed. It just sounds like this is one, the home is okay, but it could be a while before people move back in. What does a landlord do in this case?
Yeah, so this is going to be going towards, again, the implied covenant habitability. Essentially, the landlord can't breach that, even if it's a natural disaster, such as the kinds of wildfires that we're seeing right now. So that is a burden that the landlord is going to have to shoulder. So if it takes you a month, 2 months, you are going to have to forego essentially the rental income, maybe give some kind of a waiver, move them out, relocate them temporarily while you fix up the unit back to its original condition. So the burden on this one is pretty clear. It's going to be on the landlord. It's not going to be on the tenant.
Yeah, and then and this is a question for the future, but any RSO units that were destroyed by a fire, and the landlord or somebody wants to rebuild, landlord may sell and sell it to a builder. Will they need to? Will those units be subject to RSO when they rebuild?
If it's completely destroyed,
Yeah,
um,
I don't
that's
know if there's an easy answer to that one right now. It'll have to be decided.
yeah. I imagine that some of them won't be, but because you get out of it from the exemption from the new builds as well as the termination of the previous
But
tenancy.
yeah, but you have to replace. Sometimes you can't. You have to replace rent controlled units. That I guess if it's not of your own volition, if it's a natural disaster,
Yeah, I mean, sometimes, that would be in relation towards, let's say, if you're Ellising it or if
yeah,
you're withdrawing it, then you're gonna willingly impose restrictions not only on yourself but for future purchasers of value. Then yeah, you wouldn't be able to do that. But y- if the building itself was bombed or from a natural disaster like this, if you would be able to get out of the exemptions from what I could see, the regular exemptions such as new builds, or if it was just like a separately alienable property. I
yeah.
would imagine that you could make that argument.
Yeah, it'll be interesting to see because I could see some people wanting to make sure we haven't lost any of our rent stabilized apartments, but that also would compel people not to build it back if they can only charge $750 for a two bedroom, whatever the old rent was. So no, that it'll be interesting to see how it plays out. All right, so Kenny, why should we use California Property Law Group to represent us as a landlord?
So, I mean, like I said before, I think that this field of law is constantly evolving. Dates are changing, things are moving. And a lot of attorneys in this field can't keep up. Not only can they not keep up with the law, but they also can't keep up with the communication. I think that if you come to us, what you'll find is that we're very communicative, sometimes to a fault, where we'll tell you exactly what's going on. And to a certain degree, you're like, I get it. What we like to hear from our clients is that I get it, and they want it to be like, we'll see you later. If you ever do have an issue with us, we do provide free consultation. Or if you ever have an issue, we do provide free consultations, and we can provide some kind of help if you need help with your situation. And yeah, essentially, if you ever do hire us, we are very easy to reach. I'm very shocked at some of the conversations I've had with some of our clients who say they have to wait 2, 3, 4 hours to talk to their attorney, and we don't
Or
really follow
days, Kenny, or days, not just hours, days. I've talked to those people before they go to you.
that.
No, and I think the other side of it too is that you guys are honest. The fact that you're here giving advice to people, I mean, these are the kind of people you are. You give good advice, and this is advice for both landlords and renters that you're giving out right now. So I think that needs to be said as well. That you're just fair people. You're looking to work with good people. Now you do only currently work with landlords. You don't represent renters, but as you mentioned, the right to counsel may pass, so there'll be plenty of attorneys out there for renters. But we've given a lot of good advice for both sides, and I appreciate that about you guys. That's part of what I like about you guys. And when I say you guys, we're missing Raphael and Zach, but it was just as fun with Kenny.
Yeah, unfortunately, Zach had to go to the dentist, and his face is a little bit swollen up a little bit. And Rafa has a little child, so
Yeah.
I can't really fault him for that.
Yeah, that's what matters. Well, so this is the first live stream of the year. I would have never guessed when we scheduled this thing that we'd be talking about these wildfires, but I appreciate the insight that you've given tonight, Kenny. We got more of these live streams coming. I encourage you guys to subscribe to the channel and subscribe to my email newsletter. And if you need any help, reach out to Kenny and the team. They're amazing. And wow, it's only, we're halfway through January. It's going to be a heck of a year. We thought 2024 was tough. 2025 is off to
This fire makes this year feel like it's been 6 months already.
Yeah, it's like the beginning of COVID when March was about 175 days long, if you remember
And
that.
COVID was like, oh, it's only gonna be 1 month. It's gonna be 1 week. No, it ended up being
Yeah,
3 years.
no. Anyway, I really appreciate your time, Kenny. Thanks so much. That's it, folks. Thanks for tuning in. This has been Christian Walsh, real estate agent with Wire Associates, and we can't wait to hear from you.